1, and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me for this meeting are Board Members Felice Smith, Darrin Sobin. Board Member Melissa Tucker is joining the meeting virtually. Board Member Charles Nottingham is stuck in traffic and is on his way, presumably will be here shortly. The four of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask the board to please take a minute to review the agenda, and then we'll need a motion to adopt the agenda.
I'll offer the motion to adopt the agenda for today.
Okay, is there a second?
Second.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. There are no questions or comments. All in favor, please indicate by saying aye.
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 Any opposed, nays? No nays. Hearing none, the board has adopted the agenda for today's meeting. Before us today are the June 2025 draft meeting minutes. And will a member please make a motion to consider approval of the meeting minutes from June?
I'll offer the motion to adopt the June meeting minutes.
Is there a second?
Okay, I'll second.
Okay, it's been moved and seconded that the board consider the approval of the June 2025 meeting minutes. All those in favor, please indicate by saying aye.
Aye.
Any nays? Hearing none, the board approves the June 2025 meeting minutes. Next on our agenda is a report from the Office of Open Government. We'll hear from Director Niquelle Allen. Please proceed.
Thank you. Good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government. I am pleased to present this report on the activities of the Office of Open Government, also known as OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia government's operations are transparent, open to the public, and promote civic engagement. To that end, OOG has enforced the Open Meetings Act, advised on the Freedom of Information Act requirements, and provided training on those transparency laws. OOG has proudly served as advocates for an open and transparent government. Open Meetings Act and Freedom of Information Act advices first on my report. Advisory opinions. FOIA advisory opinion, DC FOIA and DC Government's FOIA portal, number OOG-2025-00M. On June 12th, I issued this advisory opinion in response to a complaint regarding the Freedom of Information Act request and the DC Government's FOIA portal. I advised the complainant on the status of the complainant's DC FOIA request and asserted that a failure to produce responsive records within the statutory period is a constructive denial of a DC FOIA request, a violation of DC FOIA, which is appealable. Further, the advisory opinion acknowledges that the DC FOIA request may not have been fulfilled timely according to the requirements under statutes and regulations, and that DC FOIA permits agencies to establish rules for DC FOIA requests. However, again, failure to fulfill proper FOIA requests is violative of DC FOIA and appealable. Finally, I opine that users with accessibility challenges due to disabilities have multiple options for submitting a DC FOIA request other than via the FOIA portal, although compliance issues regarding government technology is the province of other DC agencies. A copy of the advisory opinion is in Dropbox. OMA Advisory Opinion, Board of Trustees for Mary McLeod Bethune Public Charter School, number OOG-2025-0002. On June 27th, I issued this advisory opinion in response to a February 6th complaint, which alleged that the Mary McLeod Bethune Public Charter School Board, or the board, posted meeting minutes for only one of its meetings since February 24 and has not posted schedules for meetings since the school year 2023-2024 schedule was published on the Mary McLeod Bethune Public Charter Schools website. Also, the complainant expressed concerns about the absence of links to access to the board's meeting. I found that the board violated the Open Meetings Act as follows. 1, failure to post draft and final meeting minutes for a specific board meeting on its websites and or OOG central meeting calendar. And 2, failure to provide complete meeting notices for specific meetings, the location, valid dial-in number, and access code or valid web link and login information. Further, I determined from OOG's investigation that certain dates on the board schedules do not accord with the dates of meetings on the board meeting agenda. Concerning the meeting schedule, OOG's investigation revealed that the board school year 2024-2025 meeting schedule is posted on the Public Charter Schools website. Since this board is in violation of the OMA, they must take training with us 60 days after receipt of the advisory opinion to avoid further corrective action. The complaint and advisory opinion have been added to Dropbox. Next is informal advice. Since the last board meeting, OOG has responded informally via email, telephone, teleconference to requests for assistance as follows: 14 requests for Open Meetings Act advice, 8 requests for FOIA advice, and 10 requests for technical assistance with open-dc.gov. With respect to meeting monitoring, OOG staff attends public body meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and OOG's central meeting calendar for public meeting notices and records. OOG's attorneys provide legal advice on Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG staff have attended 13 public body meetings, and as a result of the meeting monitoring, 1 corrective measure was communicated. The public body failed to establish a quorum of its members before conducting public business pursuant to the Open Meetings Act. Next in my report is training and outreach. The Office of Government Ethics Training for Board of Ethics and Government Accountability employees. On June 5th, I, along with all of OOG staff, attended an in-person ethics training presented by OOG Supervisory Attorney Advisor Asia Stewart Mitchell. Among the areas covered at the training were ethical considerations concerning gifts to DC government employees, example of what constitutes nepotism and the consequences for engaging in acts of nepotism, conflict of interest, and the application of the Hatch Act. Office of the Attorney General for the District of Columbia Home Rule Act training. On June 11th, I, along with OOG staff, attended virtually and in person the Office of the Attorney General's Home Rule Act training session facilitated by Kevin Hilgers, Assistant Attorney General, and Ben Moskowitz, Deputy Assistant General Counsel, Legal Counsel Division of OAG. The training provided instruction about the history and implications of the Home Rule Act in the District of Columbia, which allowed D.C. residents to elect the mayor, D.C. council members, and advisory neighborhood commissioners to run the day-to-day affairs of the District of Columbia. Open Meetings Act training for boards of trustees for public charter schools. On June 11th, Attorney Advisor Joan Alelma presented Open Meetings Act training for the Board of Trustees for DC Public Charter Schools. The training provided a description of OOG's functions and an in-depth explanation and examination of the application of the OMA to public bodies, in particular boards of trustees for DC Public Charter Schools, with a brief question and answer section which which covered meeting procedures under the OMA. This training was the second in OOG's 2025 educational training series for boards of trustees for DC public charter schools. I, along with OOG staff, attended the training virtually. National Association of Attorneys General's NAAG negotiation skills training. On June 18th, attorney advisor Anthony J. Skirbo attended negotiation skills training facilitated by NAAG. This intensive Learn by Doing skills program covered negotiation and its practical application through a multidisciplinary role-playing scenario with students learning how to assess clients' interests, options, outcomes, and alternatives, negotiate effectively and productively by leveraging different negotiation styles, employ economic risk analysis in preparation for negotiation, overcome thinking errors that cause irrational behavior in negotiations, recognize and navigate negative emotions during negotiation, and gain insight and information during the negotiation process, regardless of whether a negotiated resolution is reached. And I will note that this training was provided as a courtesy through the Office of the Attorney General. Making the Open Meetings Act Simpler training to Department of Healthcare Finance. On June 25th, Attorney Skirbo presented this training to the Department of Healthcare Finance staff. The training provided a brief overview on the OMA with an emphasis on key questions and challenges that OOG has identified facing most public bodies. A primer on open meetings law training. On June 26, I presented this training to public body members and their support staff. The training covered the history of open meetings laws in the United States and provided historical context for the district's Open Meetings Act. I discussed case law regarding the public's access to government meetings and engaged attendees in a brief interactive question and answer segment of the training. OOG staff attended the training virtually. Next is the litigation and legislative update. With respect to litigation, the first case is District of Columbia versus Terrace, Plavick, and Millen, LLP, case number 21-CV-0543 in the DC Court of Appeals. I previously reported on this case, which TPM sued the district under DC FOIA, alleging that the district failed to produce and post online various budget-related documents concerning the Office of the State Superintendent of Education and the District of Columbia Public Schools. DC Superior Court denied the mayor's motion to dismiss and granted TPM's motion for summary judgment. The court ordered the mayor to produce the requested documents and to comply with the publication requirements of DC Official Code Section 2-536. The mayor appealed, arguing that documents were protected by executive privilege and that TPM lacked standing to enforce the publication provision. On appeals, the DC Court of Appeals rejected the mayor's claim of executive privilege, noting that the budgetary process involves overlapping responsibilities between the mayor and the council and thus does not fall under the exclusive purview of the executive branch. The court also found that TPM had standing to seek enforcement of the publication provision as failure to disclose the documents caused a concrete and particularized injury to TPM. The court affirmed the Superior Court's order requiring the production and online publication of the requested budget documents for fiscal years 2019 to the present. The court vacated and remanded the portion of the order requiring publications of other documents under DC Official Code Section 2-536 and instructed the lower court to clarify the scope of the required publication. A copy of the court's opinion has been added to Dropbox. The next case is Gooch versus the District of Columbia. The impacted agency is the Metropolitan Police Department. Case number 2023-CAP-002404 in DC Superior Court. I had previously reported on this case in which a requester plaintiff sued the district for records related to his conviction. The plaintiff had received partly redacted records from MPD. The parties previously agreed to work on redactions, the Vaughn Index, and to provide updates at each status hearing. A status hearing was held on March 28th. Following the status hearing, the court issued an order directing the plaintiff to file a motion by May 12th, describing the request made for information, the information received that is still redacted, and the plaintiff basis for why the remaining redactions are insufficient as a matter of law. On May 12th, plaintiff filed a motion challenging the sufficiency of the district's most recent recent FOIA production. On June 11th, the defendant filed its opposition to plaintiff motion. The plaintiff's reply is due on July 11th, and a motions hearing has been scheduled for September 2nd. A copy of the defendant's opposition has been added to Dropbox, and OOG staff will continue to monitor this case. David J. Rudo-Meckin versus the United States, case number 23-5180, U.S. Court of Appeals for the D.C. Circuit. David Rudo-Meckin was found guilty of several offenses by a military judge in 2018 and sentenced to 17 years of confinement. He filed a post-trial motion for mistrial and was suspended for inappropriate conduct. A separate military judge denied his post-trial motion. Subsequently, Rudo-Meckin submitted a FOIA request to the Army and the Department of Defense for records related to the judges involved. The government either did not respond substantively or rejected the request under FOIA exemptions. Rudo-Meckin filed a pro se complaint in district court in 2020, challenging the government's withholding of records. He later amended his complaint to focus solely on records related to the appointment of the chief trial judge. The district court granted the government's motion for summary judgment, finding that the government had adequately searched for records and appropriately withheld information under the Exemption 5 deliberative process privilege. The court also denied Rudo-Meckin's motion to amend his complaint to include his original FOIA claim regarding the Army's investigative records of the first judge. On appeal, the U.S. Court of Appeals for the D.C. Circuit found that the government did not establish that it properly withheld the record under Exemption 5's deliberative process privilege and had not shown it released all reasonably searchable information. The court reversed and remanded on this issue. The Court of Appeals affirmed the district court's denial of Rudo-Meckin's motion to amend his complaint, as his FOIA claim regarding the Army's investigatory records of the first judge was now live in a separate action. A copy of this opinion is also in Dropbox. Dr. Patrick Lentz versus IRS, case number 24-5276, and case number 06-599, formerly Pauline Stonehill versus IRS. I have previously reported on this FOIA case, which attempted to overturn a longstanding ruling regarding a dispute concerning a federal FOIA production of documents. The facts of this case date back to 1962 and concern an IRS judgment rendered against Stonehill's business. Prior to passing away, he filed a suit regarding a federal FOIA production related to this judgment. He claimed the IRS's search and production of records was deficient. The executor of his estate, Dr. Patrick Lentz, continued to pursue this matter, alleging the IRS failed to produce records. This matter is now on appeal before the U.S. Court of Appeals for the D.C. Circuit, and oral arguments have been scheduled for September 12th. Next is legislation. The first is legislative action regarding the Open Meetings Act. As I previously reported, Chairman Mendelson introduced Bill 26-200, the Open Meetings Clarification Temporary Amendment Act of 2025. On June 10th, the bill was transmitted to Mayor Bowser. The bill was returned from the mayor and enacted on June 26 without the mayor's signature as Act number A26-0086. The act is now in the congressional review period. No legislative action has been taken on Utah Senators Mike Lee's U.S. Senate Bill 1450, which was introduced in April and referred to the Senate Committee on Homeland Security and Governmental Affairs, which regarded this particular act. A copy of the act and the U.S. Senate bill are in Dropbox. Legislative action regarding boards of trustees for D.C. public charter schools. I have previously reported on Bill 26-0062, the Board of Trustees Training Amendment Act of 2025, introduced by Council Member Christina Henderson on January 17th. The bill had a second reading on July 1st and passed unanimously. At the last board meetings, a copy of the committee report was provided in Dropbox, and OOG staff will continue to monitor this legislation. Legislative action regarding a government agency's interpretation of administering statutes and regulations. Last month, I reported on Bill 26-0048, the Council Review of Agency Clarification Amendment Act of 2025, which was introduced by Chairman Mendelson on January 13th. On June 24th, the Committee of the Whole filed its committee report, and on July 1st, Chairman Mendelson introduced an amendment in the nature of a substitute concerning the bill. It passed unanimously on final reading. The bill codifies agency deference and clarifies that a reviewing court, tribunal shall defer to an agency's reasonable interpretation of a statute or regulation that the agency administers, provided that the interpretation is not plainly wrong or inconsistent with the statutory or regulatory language or the council intents. The bill largely is in response to the Supreme Court's decision in Looper Bright Enterprises v. Raimondo, 603 U.S. 369, 2024. The board was provided with a copy of the committee's public hearing record at its last meeting, and the amendment has been added to Dropbox. Last is Council's proposed resolution regarding the rules of organization and procedures for the Council of the District of Columbia. In June 2025, the Council proposed resolution, Council Period 26, Recess Amendment Resolution of 2025. The Council amended its rules to strike numerous provisions related to its meetings, including rules requiring its committee meetings to adhere to the Open Meetings Act. A copy of the proposed resolution has been added to Dropbox. Last is administrative matters. The only matter is the FY26 proposed budget. On June 24th, the Committee on the Judiciary and Public Safety reported its recommendations for review and consideration by the Committee of the Whole. The report reflects Bega's request that the Council adjust the Mayor's proposal to include funding for OOG's trial attorney position to enforce the Open Meetings Act. The report also reflects Bega's request that the Council reject the Mayor's proposal to have Bega's non-lapsing fund, formerly known as O-Fund, revert to the general fund by the end of the fiscal year. Bega also requested that the Council restore its non-personnel services funds and supplement the personnel services fund to account for step increases. This request was not included in the committee report. The Committee of the Whole is considering the circulation draft of the JPS committee report, which recommends adoption of the Mayor's proposed operating budget for Bega. A copy of the draft committee report and recommendations is in Dropbox for your information. This concludes the Office of Open Government's July 10th, 2025 report. I'm happy to answer any questions the board may have.
Thank you, Director Allen. Are there any questions for Director Allen? Go ahead.
I have a comment, not a question. I just wanted to put on the record that on June 11th, we hosted one of our communities at the DC Bar luncheon, and I was able to give a few opening remarks. And we hosted a guest speaker. Her name is Miranda Spivak, formerly of the Washington Post. And she wrote a book called Backroom Deals in Our Backyard: How Government Secrecy Harms Our Communities and the Local Heroes Fighting Back. It was about different jurisdictions across the country, horror stories about how non-transparency led to these crazy outcomes. Very interesting. I have not read the book yet, but I intend to. But she spoke quite a bit about it. And then there was a Q&A session, and I asked, even though I wasn't technically a member of the audience, I was intrigued. And so I asked her about whether she knew about the Office of Open Government here under Bega. And she certainly did. And she said, and I asked, are we kind of unique? Because what she was talking about was like all this, like, no one pays attention to FOIA. There's no such thing as the ability to go into a meeting and force it open. And I said, well, are we unique? She said, you're not unique, but you really are the gold standard in the country for how we do open meetings and transparency. You should be very proud of that. So I was like, excellent.
Thank you.
I said, that's what I do in my separate job. I'm a member of the Board of Ethics and Government Accountability. So I just wanted you to know that, because we are somewhat special. We really are. So keep up the good work.
Great.
Thank you.
Thank you. All right. Before we go on, I'll note that Mr. Nottingham has joined us, so all 5 board members are present. Okay. Next on the agenda is a report from the Office of Government Ethics. Director Cooks, please proceed.
Good morning, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, the Director of the Office of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we currently have 43 matters that are open, 1 matter open for show cause hearing for a grand total of 44. For open undocketed matters, we have 4 as a grand total. Pending state investigations by status, we have 37 matters that are closed pending collection, 3 matters stayed pending DC Superior Court case, 3 matters stayed for OIG investigation, and 2 matters stayed for U.S. District Court case for a grand total of 45. For regulatory matters by status, we have 39 matters that are closed pending collection, 63 matters that are open for a grand total of 102. Again, we currently have 44 matters that are open and 8 matters that are stayed. The number of open preliminary and formal investigations includes 10 new matters. The investigative team resolved 15 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. The quarterly complaint report for quarter 3 of fiscal year 2025 is expected to be published by the end of July to the Bega website with a press release and heat map. We will include copies of each of those documents in the Dropbox next month. Next is an update on training and outreach. First is professional development trainings attended by staff. Chief of Staff Christina Mitchell attended the Mayor's Office of Deaf, Deafblind, and Hard of Hearing compliance training. Senior Board Attorney Lynn Tran and I attended the Council on Governmental Ethics Laws, Kogel Connect, Ethics Roundtable. General Counsel Rashi Raj attended Home Rule Act training by the Office of the Attorney General. Supervisory Investigator Ronald Cook took Advancing Racial Equity MSS. For trainings conducted by staff, since the last board meeting, OGE conducted 8 training sessions, an internal ethics refresher for our agency, 3 new employee orientation ethics segments, the June and July monthly ethics trainings, a board and commissions training for the Events DC Board of Directors, and the June monthly brown bag session. On Monday, June 30th, Supervisory Attorney Advisor Asia Stewart Mitchell presented the June Ethics Counselor Brown Bag session titled Financial Disclosure 2025 Enforcement and Wrap-Up. 24 ethics counselors attended the session, and a copy of the presentation and a post-employment FDS job aid were placed in a Dropbox. During the month of June, 505 employees completed ethics training using PeopleSoft. 2 LMS training campaigns ended in June 2025. The first, an ANC training campaign, had 56 completions for ANC ethics training. The second, Bega General campaign, had 411 course completions. Since the beginning of 2025, the LMS had 1,400 users complete 1,900 courses. The training team has been meeting with LRN to discuss creating new courses and updating existing courses to make them more accessible to users. Last month, OGE started to identify low and underperforming courses to remove from our library of 29 available courses. For an update on outreach, last month, OGE issued its bi-monthly newsletter, Ethically Speaking. A copy was placed in Dropbox. Next is an update on advisory opinions and advice. First, informal advice. OGE's legal staff provided advice for approximately 30 ethics inquiries, which is 7 less than the 37 reported at the June board meeting. This number does not include responses we provided to questions regarding the lobbyist and FDS e-filing systems. For formal advisory opinions, OGE has 2 advisory opinions in the works, one on widely attended gatherings, and another is the edited advisory neighborhood commissioner sign-on letter opinion. Next is an update on legislation and rulemaking. First is the 2026 Budget and Budget Support Act proposals. On June 16th and 23rd, Bega provided testimony and answered questions that were provided by the Committee on Judiciary and Public Safety. Bega's proposed FY26 budget remains the same, which includes an increase of $139,000 to align personnel services and fringe benefits, and a decrease of that amount in the non-personnel services fund. The FY25 supplemental budget proposes to rescind $42,000 from Bega's local fund and $54,000 from the special purposes revenue. The proposed Budget Support Act includes severe changes to Bega's operating budget. The act will convert remaining funds in Bega's Ethics Fund and Lobbyist Fund, which are non-lapsing accounts, to the general fund at the end of each fiscal year. The ethics and lobbyist accounts are derived from revenue collected from ethics fines and lobbyist registration fees and fines. It was the council's intent when drafting our enabling statute that those accounts remain separate from the district's general fund. Since the creation of this agency, the Ethics and Lobbyist Fund have been used to supplement the local budget and to maintain the operations of the agency. On June 24th, the Committee on Judiciary issued its report and recommendations on the fiscal year 2026 budget for agencies under its purview. The committee recommends that Bega's special purposes revenue remain as a non-lapsing fund based on its belief that it is important that these funds remain non-lapsing as Bega's independence depends on it, as Bega's fiscal independence depends on it, and that the agency requires fiscal autonomy to operate without political interference. I'd like to publicly thank Councilmember Pinto and members of the committee for supporting Bega's budgetary needs and supporting the agency's mission and operations. Next is an update on lobbying registration and reporting, the rulemaking. OGE is in the process of amending the lobbyist section of Bega's regulations to make technical changes and clarify reporting requirements. Specifically, the amendments change the registration fee and late filing amounts to the new fee schedule that was implemented at the beginning of this fiscal year. The amendments will also include language that notifies registrants that the best course of action is to file a termination report when they don't intend engaging in lobbying activity. The proposed rulemaking was posted on May 23rd, and the final date was June 23rd. No public comments were received. 2 copies of the proposed rulemaking were placed in the Dropbox for the board's review. Next is an update on OGE administrative matters. There's just one update there. That's the OGE vacancies. OGE has 2 vacancies. One is a legal fellow and the other is a program support assistant. However, both positions have been frozen as a result of the district's hiring freeze. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the Financial Conflicts of Interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statement. The 2025 financial disclosure season has closed, and the FDS filing deadline was May 15th. OGE opened the season with 10,147 names in the e-filing system. Nearly all agencies have submitted FDRRs with addendums. Staff reviewed documents and adjusted the total number of designated filers to 9,603 filers. With the adjusted numbers, the 2025 FDS season had an overall completion rate of 92%. The next step is to finalize the enforcement list and to send fine letters to non-filers. As mentioned before, on Monday, June 30th, Supervisory Attorney Advisor Stuart Mitchell presented the Ethics Council Brown Bag Session on Financial Disclosure 2025 Enforcement and Wrap-Up. Next is an update on lobbyist registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the registrant's lobbying activities during the previous quarter. A notice for the second quarter reporting was sent on June 16th with a reminder on June 30th. The second quarter reporting deadline is July 15th. On June 25th, Attorney Advisor Eccles and Program Coordinator Kosick gave their quarterly lobbyist registration reporting training. Staff are still reviewing and confirming enforcement for the first quarter, but lobbyist activity remains strong in 2025. And the last update is public investigations. 24-0016F and 25-0002F Henry Trayon White. These are formal investigations based on 1, the criminal indictment in which responding former council member for Ward 8 allegedly received $156,000 in bribes and accepted $35,000 in cash from a business owner in exchange for assisting with renewing the company's violence interruption contracts with the DC government. And 2, allegations that the respondent violated the code of conduct by failing to file a full and complete financial disclosure statement pursuant to DC Official Code Section 1-1162.24. Investigation 24-0016F is stayed pending the outcome of the criminal case, which is scheduled for trial on January 12, 2026. Thank you. This concludes the Office of Government Ethics July 10, 2025 report.
Thank you, Director Cooks. Are there any questions for Director Cooks?
Questions, comments?
Comment. Sorry.
Comments.
Here I go again, right?
It's okay.
So I'm very, very pleased that the committee and Councilmember Pinto have recommended giving us back our O-type funds or letting them remain with us as the case may be. And just to give everyone a bit of a historical record here and for the folks who may be viewing this later, back in 2010, when the original council proceedings were going on about what kind of organization Bega should be, they looked at a lot of different models across the country, and they really wanted to make, again, the gold standard in the country. And one of the things that kept coming up over and over again was financial independence. Now, the Inspector General's office has a modicum of financial independence. I don't know the exact language, but it has to do with Congress only Congress being able to repeal some of their budget or something along those lines. We didn't have the authority to do that at Bega. And so we did the next best thing, or I should say the council did the next best thing, which was to give us these O-type funds. And while it wasn't a pure financial independence, it helped. And they let us keep our fines, and they could let us keep our lobbyists and spend it on additional operational costs or whatever we wanted to spend it on. And that's important. We fashioned Bega after the New York model, and the New York model does not have that. And the director of New York at the time, who I spoke to, said, you guys really are one step ahead of us, and we thought we were at the top, but because of this, you guys really are one step forward. And I've made arguments, he said, over the years as to why we need it. It always fell on deaf ears. And so kudos to you, not to me, but to DC and the council and the mayor for doing these O-type funds. So I'm glad this has happened. And I do believe that this was not on the executive's mind when it was recommended that we remove our O-type funds. I do believe that this was something that fell through the cracks, and that now that it's been recommended, I think it will go through. So I just wanted to say that. So I'm glad you were able to push that. Good job. And again, I think it's important for this organization that we retain control over our O-type funds.
Thank you.
That's all.
Thank you. The next item on the agenda are public comments. Members of the public in attendance at the meeting have an opportunity to make a comment at this time. If there are any such members of the public, this is time for you to make a comment. Okay. If there are no comments from the public, we'll proceed with the next item on the agenda, and that's our executive session. Okay. This session is to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B14, to consult with an attorney to obtain legal advice, to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters, including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiations pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
So moved.
Is there a second?
Second.
Okay, so moved and seconded that the board enter into executive session. All those in favor, please signify by saying aye.
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 Any opposed? The motion passes unanimously. Board members, please move over to the boardroom for the executive session. We will return to this meeting after the conclusion of the executive session to report out any matters decided, finish any other business, and adjourn the meeting. Thank you. It's now 11:39 and we're back on the record. The board approved the following four negotiated dispositions in these matters. 24-0070-P in Ray A. Hannah. 24-0124-P in Ray N. Smith. 24-0141-P in Ray B. Irving, and 25-0070-P in Ray T. Clements. The board also approved a notice of violation in matter 25-0002-F in Ray Trayon White. With that, the time is now 11:40, and this concludes the meeting of the DC Board of Ethics and Government Accountability for July. Thank you and have a great rest of the month.